While viewing this program, you will hear the phrase, your school district, several times. It should be noted that the definition of driver liability expressed herein applies also to drivers employed by transportation contractors. Any variables in the application of liability laws resulting from variances in state laws or other factors will be explained by your employer. As a professional school bus driver, your job has special demands and requirements, and you must be willing to accept the responsibility of protecting your passengers from harm. Still, the one question often raised by school bus drivers is, if I have an accident which seriously injures another person or causes substantial damage to someone's property, how well am I protected against a liability suit? This question is quite valid, and the answer is important for you to know. But before we consider this question, we need to define what is meant by the word liability. Very simply, liability is based upon fault. If an individual is not judged at fault in an accident, then obviously that person has no liability. Fault or liability can only be determined by two means: in a court of law or in an out-of-court settlement reached between the individuals or insurance companies involved. Often school bus drivers will ask, if I do this or if I do that, could I be held liable or at fault? Lawyers and judges tell us that before you can be held liable for injuries resulting from negligence or considered at fault, these four conditions must be present: duty, breach of duty, cause, and damage or injury. If one of these conditions or grounds for negligence is missing, then the other three are invalid and you cannot be held liable. Let's spend some time discussing each of these conditions. The first condition is duty, the obligation to perform. In determining liability, there must be a particular duty that you must perform. Obviously, your primary duty as a school bus driver is the safe transportation of children to and from school. But transporting students safely to school is made up of many additional duties, such as obeying traffic laws, federal laws and regulations, school board policies, and the rules of your state's official school transportation authority. One example of a very important duty is your daily pre-trip vehicle inspection. As a bus driver, you're probably required to perform a daily inspection of your vehicle and report for repair any defects or deficiencies discovered that may affect the safety of the vehicle's operation or result in its mechanical breakdown. This is an example of a written duty. But let's go one step further. The question arises as to how much care is required in performing this duty to avoid liability in the case of an accident caused by a mechanical failure. Do you have to pull a wheel to see that there's adequate brake lining? Or do you have to stop the bus and check your lights every mile to make sure one hasn't gone out? Obviously not. Duty is looked upon by the courts as the degree of duty that should be performed by a reasonable and prudent person. Those acts which performed by a reasonable person with the best interest of other people or life or property in mind. Unfortunately, this is very difficult to define because the degree of care or manner of operation required of a driver in one situation may be totally inappropriate in another situation. For example, there's a record of a court case involving a 6-year-old student who had been transported by a school bus a total of only 3 times. The first 2 times, the driver allowed the child to get off in front of his house. The third time, the student was unloaded from the bus across the street from his house. While attempting to cross the busy street, he was struck and killed by a passing motorist. Both the driver and the school district were found liable given the circumstances. The child was only 6 years old. He was unfamiliar with the proper procedures for crossing a busy street after getting off the school bus. And he had ridden the school bus only 3 times. So the court felt that the driver and the school district breached or failed to assume the proper degree of duty for that given situation. Historically, many accidents resulting in injuries or death occur at loading and unloading sites. Therefore, bus drivers must assume a high degree of care during these procedures to assure the safety of their passengers. Now, if this had been a 16-year-old student, the chance of liability may not have been quite so great. With a history of school bus transportation, including training, a 16-year-old student of normal intelligence and physical ability should be able to assume some degree of responsibility for his or her own actions. Here's another example of a situation that occurred at a loading site near a school. The driver had pulled up behind another bus waiting to load children at the school. The students, seeing the buses, ran from the building where they had been waiting because of the cold weather. The driver of the first bus had finished loading and pulled forward. So the driver of the second bus started to pull forward also toward the point where he was going to load his students. By this time, the children had reached the bus, and one of them slipped on some ice and fell beneath the rear wheels of the moving bus and was killed. The court found the school district and driver liable because of the particularly dangerous circumstances present at the time of the incident. These included a bus moving while in the same area as small children, the young age of the children, they're not expecting the bus to pull forward, and the icy conditions that existed at the loading site. In this case, the driver's degree of duty was greatly increased because of the number of hazards that existed. From these two examples, it is obvious that the degree of duty or amount of caution you must exercise will depend upon the situation that exists at the moment and may change rapidly because of such unpredictable factors as weather, traffic, roadway, or the age and training of students involved. That means your duty as a school bus driver will, in most cases, be determined by your own good judgment. Next, in determining fault or liability, someone has to do something wrong. Duty must be followed by a breach of that duty or a failure to perform a duty, whether it be written or dictated by common sense. What determines when a breach of duty has taken place? There is obviously no question that a driver failing to stop for a stop sign at an intersection has failed to perform a legal duty. However, it is much more difficult to determine breach of duty in cases involving common sense or judgment situations. In these situations, courts like to apply the term foreseeability in determining whether a person should be considered at fault. If the court rules that a driver could or should have foreseen the hazard and failed to react as a reasonable person would in that situation, this may be considered a breach or failure to perform a duty. In the case of the school loading area accident where the child slipped on the ice and was run over by the bus, the court probably based this decision on whether a reasonable person could have foreseen the potentially hazardous conditions that existed in that situation. Another court case in which foreseeability played an important role involved a 16-year-old girl being unloaded from the bus in front of her house. All unloading procedures were followed by the bus driver. Lights were activated, and there was the required amount of rear-view visibility. As the student exited and moved away from the bus, she was struck by a motorcycle passing the bus on the right side. The bus driver had checked the rear-view mirror before the student exited and saw nothing. In this case, the court ruled that the driver had no reason to foresee that the motorcycle was going to pass on the right. In addition, the motorcycle was going at a high rate of speed. Therefore, the court found no fault or liability on the part of the school bus driver. The third condition that must exist before liability can be established is cause. The failure to perform an obligation must be the probable cause of injury or damage. Did the breach of duty, in fact, cause the injury or damage? Most of the time, it's quite evident that the breach of one or more duties was the cause of damage or injury. In a given case, however, not all injury or damage is visible, nor does it always surface immediately following the mishap. Some people even try to claim damages that were not related to the accident. This type of case is usually taken to court for a decision. An example of this type of court case took place several years ago. Although the case is an old one, courts look back on these cases to see what decisions were made previously and what bearing they may have on current cases. In legal terminology, this is called precedent. In this case, a school bus rolled over, and as a result of the accident, a child sustained an ear injury. The ear injury developed into an ear infection and later was fatal to the child. The Supreme Court studied the case to determine whether the accident was the cause of the ear infection and eventual death, or if the ear infection was the result of a previous bout with rheumatic fever. It was finally ruled that the ear infection resulted from the school bus accident. So you see, if a reasonable connection can be made proving the failure to perform a duty, in this case, failure to have control of the bus, results in an injury, then liability can be determined. The fourth and final condition involves evidence of actual damage or injury. Visible damage is the most easily identified. The evidence of damage to a person or property is physically evident. However, as we saw in the last example, invisible or delayed damage or injury is harder to identify or prove. Physical or mental damages may surface some time after the incident. But in most cases, without injury or damage, there can be no fault and therefore no liability. There you have the four conditions that must be met before you or your school district can be liable or at fault for an accident. First, there must be a duty to perform, which can be in the form of a written law or policy, or it may be an unwritten duty that a reasonable person might be expected to perform out of sheer common sense relating to the situation. Second, it must be proven that there was a breach of or neglect to perform one or more duties. Third, the failure to perform the duty must be the cause of the injury or damage. And finally, there must be evidence of injury or damage directly related to the failure to perform a duty. The absence of one or more of these conditions will, in nearly all cases, eliminate the possibility of you or your school district being held liable. Now let's address the question which was asked at the beginning of this program. If I have an accident which seriously injures another person or causes substantial damage to someone's property, how well am I protected against the liability suit? Most school districts or other governmental subdivisions were at one time immune or protected against lawsuits. This probably goes back to the English philosophy that the king can do no wrong. Instead, suits were filed against those individual employees involved, such as a teacher, a city council member, or a school bus driver. However, it was later felt that the employer, such as the state, city, county, or school district, had an obligation to the people it served and should be held responsible for the actions of its employees. So in the late 60s, legislation was passed in many states which waived the immunity of political subdivisions, and what is typically referred to as the Tort Claims Act was adopted. This legislation made it mandatory that liability claims be the responsibility of the governmental subdivision involved. Simplified, a Tort Claims Act generally provides that the only way a person can recover damages for acts of employees of a school district, such as a school bus driver, is by suing the school district. If the driver of a school bus is named in the suit, it's up to the school district to provide legal counsel and defend the driver. Should the case be lost, the act could protect the school bus driver from personal financial loss. The terminology usually used when dealing with tort claims involving school employees is to save harmless and indemnify. This means to secure the employee against hurt, loss, or damages for actions taken by employees who are acting within the scope of their employment duty. There are, however, two conditions or actions that, when proven to have been committed by an employee, could in most cases relieve the school district from payment of punitive damages awarded in a settlement. These two conditions are willful or wanton acts and willful or wanton omission, which result in damage, loss, or injury to persons or property. An example of a willful or wanton act might be found in this situation. The driver of a school bus approaches an unloading area at a school which is restricted to school bus use only and finds a car parked in the way. The quick-tempered bus driver decides to teach the driver of the auto a lesson and proceeds to push the auto out of the unloading area with the school bus. As a result, The auto receives extensive damage and its driver receives a serious neck injury. In this case, the school district would still have to provide legal counsel and defend the school bus driver if a suit was brought against the school and bus driver. However, the school district would probably only be responsible for the payment of actual damages, such as repair of the auto and payment of any medical bills incurred by the auto driver. If, however, there are also punitive damages awarded in the settlement, which is usually an additional monetary payment granted by the courts as a punishment for the act, the school may not be responsible for payment of such an award under the provisions of a Tort Claims Act. Monetary awards for punitive damages can, in many instances, equal or exceed the cost of actual damages or injury caused by the act, and these costs might, as in the case just described, be the responsibility of the bus driver. The second condition for which the district may not be held responsible for punitive damages awarded is in the case of any willful or wanton omissions. This can cover a multitude of areas. However, the term omission generally refers to apathy toward or neglect of a specified duty or responsibility, whether in verbal or written form, or a duty born out of the expectation to act as a reasonable person. Duties which might willfully and wantonly be omitted or neglected would include school board policies, traffic laws, state rules and regulations, as well as common sense duties or responsibilities. Obviously, there are going to be occasions when a policy or law will be unintentionally disobeyed or broken. This is only human nature. However, there may be instances in which an employee willfully disobeys a law or policy. If this can be proven, usually in a court of law, a Tort Claims Act would not protect the employee against the responsibility to pay punitive damages. For example, let's say that a school bus driver has been properly trained and repeatedly warned by the Director of Transportation not to travel a particular roadway because the bus has to cross a bridge that the school board has decided is too narrow to be safe. But by taking this roadway, the driver can cut 10 minutes off the total route time. So on a winter day, after running a few minutes behind schedule, the driver decides to pick up the extra time by taking the forbidden road. As the bus approaches the bridge, it hits an icy spot in the roadway, causing the bus to strike one side of the bridge railing, skid across the bridge, and overturn into a ditch on the opposite side of the roadway. In this hypothetical situation, if the Director of Transportation or the school district has documented evidence that the driver had been warned prior to the accident not to travel the road, and it can be determined that the act or omission was willfully in violation of a well-defined and communicated district policy, the driver may eventually be held responsible for payment of punitive damages awarded in a lawsuit. In this program, we've shown that as a professional school bus driver, you have a responsibility as well as a legal duty to perform your job with a high degree of care. We've discussed the 4 conditions for determining liability. 1, duty, the obligation to perform. 2, breach of duty, failure to perform that obligation. 3, cause. The failure to perform that obligation must be the probable cause of injury or damage. And 4, there must be actual evidence of damage or injury. When applying these elements to any real or hypothetical situations, you can usually determine whether fault or liability exists. And remember, all of these 4 elements of negligence have to be present to prove liability. We've also discussed the potential for personal fault or liability on the part of a school bus driver in the event it can be proven, usually in a court of law, that willful or wanton acts or omissions were committed. Yes, accidents do happen, but you can help protect yourself from liability by becoming thoroughly familiar with your school district's policies and following them carefully. Then you can drive your bus each day knowing that you are well protected against a liability suit because you are performing your job to the best of your knowledge and ability.